So I'll just kind of maybe get things rolling a little bit. My name is Clay Fong, and I'm the manager of the City of Boulder's Community Mediation Service. We do a lot of landlord-tenant issues, resolving conflict around that for the city. My colleagues Diane Evans and Karen Armstrong are here this evening as well, and they'll also be helping out tonight. What we're going to do is just kind of walk you through what some of the options and issues are. We're very fortunate to have a distinguished panel of 5 of the top landlord-tenant attorneys in town here to answer some of your questions. The other thing is, and I'm not sure because I just, we can't anticipate the volume, but there is a resource which is listed in the handouts, which is the Colorado Bar has set up a free legal advice line, and there's a phone number which is in that handout as well as a website where you can sign up to do that kind of thing. I'm hearing music from somewhere. But where you can sign up and get free legal advice from the Colorado Bar Association. They've set up that resource as well. And a few other things is that there is an email sign up. If you want to sign up for updates, just to give you an example of why you might want to do that, there may be a follow-up meeting to this. We don't know at this point. Secondly, my understanding is that City Council is going to be looking at some issues around this that may have an impact on landlords and tenants. My understanding is that next week's City Council meeting, they will take the question of occupancy limits into consideration because there is some thought that there may be some suspension of that. I can't say whether they will or not, but that is on the agenda for next Tuesday's City Council meeting. So if we get information on that, we would send that out to people who sign up on that email. The other thing I would mention is that we already have done some mediations around flood issues through the mediation service. So if you need assistance and if the property is located within the Boulder city limits, we've helped landlords and tenants negotiate the end of the lease and what that looks like, timing, what money, if any, changes hands, security deposits, key returns, etc. So we also offer that as a resource. Ours is a low-cost service, but we will also waive fees if there is financial hardship. So we don't want money to be a barrier to using the city's mediation service. So we're going to start tonight with an explanation of the warranty of habitability, which is really where a lot of the law surrounding this stems from, and then we'll sort of open it up to questions. And I'm now going to turn it over to my colleague Karen to sort of take up other issues about how this evening will go.
I just also want to acknowledge, I know many of you have been through quite a bit over the last 2-3 weeks. And we really want to be here as a support in whatever capacity we can in our positions here. And but we've heard a lot of stories over the last few weeks, and we do extend our sympathy, compassion, and hoping that tonight's presentation will at least help answer some questions for you. So we have a question sign-up sheet, and we just ask that you keep your questions concise. There's going to be a lot of people tonight, so just keep your questions really brief. And as we go along, I suspect there's going to be a lot of repetition in the kinds of questions that are coming up. We've heard maybe the same 5 basic questions, variations of those in our office. So if you feel like your question's been answered sufficiently, just let us know and we'll go on to the next person. And I think that is it. So we'll go ahead and turn it over to the presenters for tonight, and I'll let them introduce themselves. And we're very happy that they volunteered their time tonight to be here.
Okay, my name is Karen Burns. I'm a sole practitioner in Boulder, and I do landlord, tenant, and workers' compensation law here in Boulder.
While you're here, can you get the mic closer to you?
Sorry.
Is it turned on? Yeah, they should be on.
Okay.
You might want to lean in.
My name is Karen Burns. I'm a sole practitioner attorney here in Boulder, and I do landlord-tenant law and workers' compensation.
My name is Jack Alexson, sole practitioner, primarily general practice, do a lot of landlord-tenant law. I've been practicing in Boulder for 44 years. I'm the old man on the panel.
Greetings, my name is Victor Grimm. I've been practicing here in Boulder for about 20 years or so. practice in the area of real estate and landlord-tenant law. I wrote a book called Landlord and Tenant Guide to Colorado Leases and Evictions. I'm not trying to flog it tonight or anything like that, but it basically talks about rights and responsibilities of landlords and tenants.
My name is Philip Bienvenu. I'm with the CU Student Legal Services Office. I've been a lawyer here in Colorado for 33 years now, and here in Boulder for 17 years. Our office practice is largely divided between landlord, tenant, and criminal defense.
My name's Bruce Sarbaugh. I'm actually a Boulder native, so I grew up here, seen the whole landscape change dramatically in the last 50 some odd years. I am a sole practitioner also. I started my practice in about 1993 in landlord-tenant. Had the distinct pleasure of having Mr. Allison as my mentor on a number of occasions, and have had the honor of actually opposing him in a number of cases.
And beating me up too, yeah.
Not necessarily. But I also work up at the university with off-campus housing, working directly with the students in landlord and tenant issues. 2 days, I only do that 2 days a week, and then the other 3 days I'm in my private practice, which includes landlord-tenant as well as criminal defense, which with the students tends to go hand in hand sometimes.
Before we get started, I also want to just acknowledge Claire Hunter with the District Attorney's Office Consumer Protection helped to put this together as well and secure some of the speakers. Did you want to say anything about what you do?
I'm with the Consumer Office. We changed the name this year to Community Protection because we're doing more with the community, elders, seniors in the community. If you have a question, you certainly can give us a call. We're at the DA's office, and if I can answer it, I'll turn you over to community mediation or refer you to a private attorney. I'm not an attorney, so I cannot give you legal advice, but I can tell you what I found through just many years of working landlord-tenant and what the laws might say, or to guide you through the process. So please give us a call if you want to. It's 303-441-3700, and the DA's will answer and put you through to us. All calls are welcome. Excuse me? It's Community Protection, and it's a part of the DA's office here in Boulder at 6th and Canyon. And my name is Claire Hunter, and we have 3 or 4 staff members, and we have 6 volunteers, 4 of which have major flood problems themselves. So they haven't been in the office, and I don't expect to see them probably for the next 2 months. Thanks, everybody, for coming.
Good. So I'd like to start this off just by giving you guys a little overview of the warranty of habitability that exists in Colorado. It's sort of interesting to note that until 2008, we did not have a warranty of habitability in Colorado. We were the second to last state in the nation to adopt a warranty of habitability. The last state is Arkansas. They still do not have one, but we do. And so I'm going to give you sort of an overview of that. In addition, I'm going to talk to you about a couple of related concepts that aren't in this. There's 2 different types of law. There's the statutory law, that's the law that's created by the legislature, but then there's also case law that's created by the courts. And I'm going to talk a little bit about some ideas under case law known as constructive eviction and the covenant of quiet enjoyment, and give you guys some. These are all sort of tools or ways to address issues that you might be dealing with in a flood situation. So first of all, the legislature adopted it in 2008, and it creates duties on landlords with regard to a landlord-tenant relationship. It creates duties on tenants with regard to a landlord-tenant relationship. And then the last thing it does is, if either the landlord or the tenant breach those duties, it gives rights and remedies with regard to those duties. So first of all, let's talk about what the landlord has to do. Basically, the landlord has to provide premises that are habitable. And if they're not habitable, then the tenant has the right to essentially undertake certain remedies. There's 3 steps to the process. If the landlord does not provide premises that are habitable, the tenant needs to show that the premises are uninhabitable, Number two, this is an addition, it's not an or. They need to be uninhabitable, number one. And number two, they need to be materially dangerous or hazardous to the tenant's life, health, or safety. So you need to have both of those, uninhabitable and materially dangerous. The third thing you need to do is that the tenant needs to give notice to the landlord of the condition in writing and give the landlord a reasonable period of time to cure that particular condition of the property. So that's sort of an overview of the law. Let's talk about each of these elements in a little bit more detail. And most of our time is going to be spent doing question and answer. This will take about 5 minutes. It'll be painless. So first of all, what constitutes uninhabitable? Well, the statute has a laundry list of matters that could create an uninhabitable condition on the premises, and I'm just going to go through those very quickly. First, the premises are deemed uninhabitable if they substantially lack any of the following characteristics: waterproofing and weather protection of the roof and exterior walls, plumbing or gas facilities that conform to applicable law, running water and reasonable amounts of hot water at all times, functioning heating facilities, electrical lighting with wiring and electrical equipment that conform to the applicable law. Common areas that are under control of the landlord need to be kept reasonably clean and sanitary. Appropriate extermination in response to infestation of rodents throughout the premises. Adequate number of appropriate exterior receptacles for garbage. Floors, stairways, and railings maintained in good repair. Locks on all exterior doors, security devices on windows. Compliance with all applicable building, housing, and health codes. The list isn't exhaustive because the statute also has sort of a catch-all at the bottom, and it says that uninhabitability can also exist if the premises are found to be otherwise unfit for human habitation. So that sort of covers pretty much everything else. So that's the first part, uninhabitable. The second part is that the property has to be materially dangerous. The specific statute, the language of the statute specifically states, materially dangerous or hazardous to the tenant's life, health, or safety. So what the heck is that? The legislature really doesn't give us any further guidance on that second element. And there really is not a lot of case law out there where the courts have interpreted that second element. But it is important to know that there are those two elements. If you have those two situations, you have those two elements that are satisfied, then what the heck do you do? Well, you need to give the landlord a written notice of those conditions and give the landlord a reasonable period of time to cure or fix those conditions. How the heck do you do that? Well, there's a handout that I provided. It looks like this. Hopefully most of you guys got it. If you guys did not, what I can do is provide it to the city, and maybe they can put it up on their website. But essentially, it's not required by statute, this particular form, but it's a form that I drafted and Bradford Publishing has published that essentially hits all of the information that you need to tell the landlord about. So I want to spend a little bit of time on this notice. The notice says, or the law says, you need to give the landlord a reasonable period of time to cure the problem. So what the heck is a reasonable period of time? It really, does it depend on the condition that the premises are in and the condition that you're living in? Or does it depend upon, given, I'm a landlord as well, I've been trying to get a roofer out to my property for the last week and a half and have not been able to do so because of all of the calls. And so, once again, the statute does not define what a reasonable period of time is. But once the reasonable period of time has passed, you've given the landlord that notice, and if the landlord has not corrected the defect, then the tenant has certain rights that the tenant can exercise, remedies that they can pursue. The first one is that the tenant can ask for a termination of the tenancy, or not ask for one, but basically state that the tenancy is terminated. How do they do that? Well, I have a second document that's attached here to the handout. It's called Notice of to Remedy Breach and Notice of Termination for Breach of the Warranty of Habitability. That's the second form in the handout there. And it basically says, hey, landlord, I gave you a reasonable period of time to fix this. You did not fix it. I'm now giving you an additional 5 days. So in fact, there are 2 different notices. You have to give one notice, giving them a reasonable period of time to cure, and then an additional 5 days. This is your final chance. And if you do not fix this within 5 days, then I am going to terminate the tenancy. What does that allow you to do? That allows you to leave, terminate the tenancy, basically stop the lease from proceeding. And you need to give the landlord that notice, give them the 5 days, and you need to specify a time when the lease is going to terminate, 10 to 30 days from the date that you give that notice. So that's one remedy that tenants have under the warranty of habitability. A second remedy that the tenants have is a right to go and seek injunctive relief from the courts. What does injunctive relief means? It basically means that you can go to the courts and say, court, landlord's supposed to maintain this property in habitable condition. They didn't do it. I gave them the appropriate notice. They still didn't do it. I want you to make them do it. And so the law allows you to ask the court for that type of relief. The third type of remedy that's available is that a tenant can seek damages. What types of damages? Basically, the statute says that actual damages can include a reduction in the fair rental value of the dwelling unit. So what does that mean? Well, if it was not as nice as it was when it was let with the defective condition in there, you can seek a reduction in the rental amount. I want to underline here, that doesn't mean that you can simply withhold rent and stop paying rent, but you can seek damages against the landlord, and that might relate to a reduction in rent. Number two, you can also seek attorney's fees. But you need to be careful with the attorney's fees provision, because the law states that you can only seek attorney's fees if your underlying lease allows you to seek attorney's fees with respect to the lease. A couple of other things to keep in mind. There is a provision in the warranty of habitability that says nothing within this law will be construed to apply in the situation of a catastrophe occurring on the property. So I'll give you a citation of that real specifically, and that is 38-12-5036A. It says nothing in this part shall prevent a landlord from terminating a rental agreement as a result of a casualty or catastrophe to the dwelling unit without further liability to the landlord or the tenant. So that's a big open question as far as what that means. It, to my knowledge, hasn't been litigated, so we don't know about that. I'm going to talk about two related concepts, and that is the idea of a constructive eviction, which, after looking at the warranty of habitability, is pretty darn simple. Constructive eviction has two elements, and this is once again law that was created by the courts. It's not a statute, but there's a specific case out there that says that these common law concepts still exist, even though we have the warranty of habitability on the books. And the constructive eviction, what is required is two things: denial of the use of the premises where the premises are rendered unfit for occupancy. So basically, the premises are unfit for occupancy, and there's many cases out there talking about what makes property unfit, including flood damage. There's specific cases out there that talk about flood damage. And number two, abandonment of the premises by the tenant within a reasonable period of time. That means you can't just sit there and say they're uninhabitable. You have to get the heck out of the premises and do that within a reasonable period of time after they've been rendered uninhabitable. That's the concept of constructive eviction. There's another related concept called a breach of the covenant of quiet enjoyment. What the covenant of quiet enjoyment states is that the landlord basically owes a tenant the right to quiet enjoyment of the premises. That doesn't just mean not having noise on the property, but a breach of the quiet enjoyment occurs when there's a disturbance of a lessee's possession by the lessor, which renders the premises unfit for occupancy for the purposes which they were leased. And that concept is related to constructive eviction. It doesn't allow you to leave the property, but it can be a claim in a lawsuit. It can also be a counterclaim in an eviction action or a defense in an eviction action. So that's sort of an overview. I know it's a lot of legal gobbledygook, But at the same time, I hope it gives you sort of an idea of, when we start answering your more specific questions, the framework that we're working in.
Do you want to mention something about the, specifically the flood in the section that talks about casualty or catastrophe and the right to terminate?
Yeah, well, you bring up a good point, Jack, and the specific sections talks about catastrophe, and it says nothing in this law precludes the landlord from basically terminating the lease. But what it doesn't do, it doesn't talk about, and I don't know if this is what you're getting at, you also have to take a look at the underlying lease. Is that your thought, or did you have some other?
I just thought that most of the damages are related to a catastrophe or a casualty
Right,
because of the flood.
sure. But the
A lot.
extent of it, is that what you're thinking?
Well, a lot of landlords, I think, are terminating the lease under that section.
Mm-hmm.
You'll notice, I assume that most of you here are not landlords, is that correct?
Why don't we see
That's for a show of hands.
Yeah, that's a good idea. Show of hands.
Who's a landlord? Who's a tenant?
Tenants?
What I was going to say, you'll note that specific statute says the landlord can terminate the lease. Give that right to the tenant. And so if you are the tenant and you're in a catastrophic situation and you go to your landlord and you say, I'm terminating my lease because it's a catastrophe, what you have to show first, as Victor said, are either one of the elements underneath, those underlying elements of the warranty of habitability and or constructive eviction. And you'll notice when you go through each of those elements in the warranty of habitability, it talks about in violation of applicable code, which means local codes, building regulations, and things like that. So there's a lot of different layers to the warranty of habitability.
And I guess I'll chip in here. It won't surprise any of you that lawyers may disagree among themselves from time to time. But what I want to say is that, in fact, I think this statute does allow the tenant to terminate a lease, but you have to go through more steps. It makes it easy for a landlord to say, this is a catastrophe, I'm terminating your lease. They can do it just that easily. For a tenant, you have to give the notice, you have to wait the time, and then you have to go ahead and make the decision that you're out of there, turn in your keys and so forth, and give further notice to the landlord that you are terminating it and leaving it. There's some disagreement, I predict, on what to do with the way the word reasonable gets used in there, because I think, for one thing, if the habitability problem is I don't have hot water, and I tell my landlord that, I think it is reasonable for me to wait a few days and see if he puts in a new water heater or fixes the problem otherwise. And a reasonable time might be 4 or 5 days. And if it's still not happening, I might give the notice and say, okay, now we're serious. 5 business days, or I might terminate my lease. And it gives you that right. This is a situation that's very different from that. This is not my hot water's not working. This is, a basement apartment or a ground floor apartment, maybe virtually completely gutted or ruined to the point where it has to be completely reconstructed. And the reasonable landlords are admitting that. And they are proceeding to terminate the lease. And I have, I don't even know whether I should use the name, but I've seen tenants from one realty in particular. I was really impressed with how they responded to the situation, because what they've notified their tenants is, first of all, we want you to get your stuff out of there quickly by Sunday night. And if you get it out by Sunday night, then you can turn in your keys Monday. We'll do a walkthrough with you Monday. We're terminating your lease. We're going to refund your security deposit Monday, and we'll return 2/3 of your September rent Monday, because that's the fair way to do it. And when tenants came to me with that paperwork, I had to tell them, I can't argue with any of that. That's fair. That's maybe even better than the statute requires, because you might have the right to hold off on returning the security deposit because you've got that time limit under the lease. But these folks were doing it, they knew these people needed money, but it was hopeless to make them wait around and tell them, no, you're still on the lease. We don't know when we'll have your place fixed for you to return. Meanwhile, they're homeless. I mean, this is not hot water. This is, you're homeless. You're out on the streets. trying to sleep with friends or whatever. It's a different situation. So I think in this situation, what reasonable probably means is if you want to terminate the lease and your landlord's not going to do it, I go ahead and give the 5 business day notice letter in the same letter with the specific description of what the problem is, because if it's impossible to fix it in a reasonable time, and that's the way I'm reading the situation for a lot of these people, then we don't have to give a notice, wait a reasonable time, and then give a second notice. I'm giving one notice and it's accomplishing both, and I think it's fair under the circumstances, and I actually think that's the only fair way I can read the statute. Otherwise, we're telling tenants, you're homeless, we don't know how long it's going to be. You still have a lease with me, I'm going to try to fix this. I don't know how long it'll take. We don't know what reasonable means because the whole Front Range is using construction crews, and I don't know when I'll be able to get one. So you just be homeless for now, and whenever I get it finished, I'll let you know, and then you come back on your lease because you're still going to owe me rent from that part on. There's some that are even trying to collect rent during this time period when the place is unlivable, and I'm pretty sure the law doesn't support that. No lease would be good enough to accomplish that. If you can't live there, you don't have to pay rent there. And I've probably talked too long, but anyway, that's my take on it. It might be different from how other people feel.
Phil may be astounded, because I actually agree with him. We disagreed on that specific point initially, but I agree with him because I think there's a definition of the notice provision. Initially, as Victor was saying, there's a first notice part. That doesn't have to come from the tenant. That has to be noticed from some place to the landlord. It doesn't have to be written, but it can come from an inspector, it can come from a contractor, it can come from a police officer. But it has to be some kind of notice of the condition that's making this house uninhabitable or making it materially hazardous health to your health. So I think there's support in the law for what Philip is saying, that right at this point, all you have to do is give that 5-day notice period of the notice of termination.
It does have to be in writing, of course.
Yes.
And as a follow-up, if the lease is terminated, the tenant leaves, you want to be sure that you have contact with that person, because once the property is restored, you want to see if he wants to come back, he or she wants to come back and sign a new lease under the same terms, because they have a right to come back and occupy that unit once it's repaired. You can't go ahead and lease it to somebody else at a higher rent or anything else. You want to keep contact with that tenant and see if they want to come back after the property is restored to a habitable condition.
Karen, do you have anything?
Yeah, actually, there's another provision that allows a tenant to terminate through the warranty of habitability. And it's something that we ran into last week. We gave a talk up in Lyons and Longmont, and many of the people were from Lyons and Jamestown. And frankly, no one is going to be able to repair anything in many of those locations. There is another provision that says if it is impossible for the landlord to repair the items that make the house uninhabitable due to circumstances beyond their control, then the tenant's only option is to terminate the lease. And this is going to come into play, I think, more than we think, because I can't imagine anyone being able to drive up to Jamestown right now and fish people's houses out of the river. And it's not, I mean, I'm saying it's much more serious than a broken furnace in the middle of the summer. So just, you need to know that, because it may just be that repairs cannot be made in any way. I mean, maybe for months.
And I think, what's obvious among all of us up here is that there's an awful lot of confusion within this law and ambiguity within this law, which makes it incumbent upon both landlords and tenants. This stuff only comes into play if you go to court and you're fighting in front of a judge. It makes it even more important to work with, if you're a landlord, to work with a tenant, if you're a tenant, to work with the landlord, to try to negotiate a reasonable solution. It's very, very good to know the law so that you know what parameters you're negotiating with regard to and what your rights and responsibilities are, but you don't know what the heck the judge is going to decide when you get to court, if you get to court, and I think all of us up here would agree you don't want to go to court. You want to work these things out in another way.
Well, you probably all know you're better off if you can avoid lawyers and courts.
It's the bane of our profession.
All right, well, I guess we'll go ahead and jump in with the questions here. One question that we have written down here, and I think you may have already addressed it, let me know if there's anything more to add, about the warranty of habitability, the length of time required to make repairs will depend upon the extent of damage. If repairs are being made on a continuous basis or attempts to arrange contractors, will this be construed as constituting a reasonable time?
I think it brings up two good points. Reasonable according to who? Reasonable according to the landlord or reasonable according to the tenant? And I'll give you my personal example of my tenant where I have water damage, and I've tried to get a roofer to come out and give me an estimate without much success. My tenants have been wonderful as far as just sort of being very patient with me. But at the same time, I could understand if I had a different set of tenants and they said, this is unacceptable, this is not reasonable for me. I understand life sucks that you can't get a roofer out here, but that shouldn't be my problem. I need a reasonable place to stay. So I guess my answer to the question is, who knows? It could be either the tenant or the landlord.
I have a little bit, kind of more maybe common sense or practical, I guess, approach. And that is, number one, my advice would be communicate. If you're a tenant, communicate with your landlord. If you're a landlord, communicate with your tenant. If you have trouble getting a roofer out, let the tenant know. Like, look, here's the emails. You know, copy the tenant on the emails to the contractors. But let the tenant know that you're dealing or trying to do what you can. You don't have to go to extraordinary measures, but you're being reasonable in your efforts to make repairs. The most problematic tenants I have come in and they say, I can't get a hold of my landlord. I don't know what's going on. I have no idea when we're going to be able to move back into the basement. There are 5 kids living in a living room in one house. So communicate. And if you're doing those things, you're going to know, and the tenants are going to know, and the definition of what is reasonable kind of resolves itself.
You know, a couple of guys living with a leaky roof and a bucket, they might be willing to put up with that for a couple of months. But if it's a situation where it's humidifying the house and it's a young couple that's got 1 or 2 babies, you know, and they just don't feel that they're in a healthy environment for their kids, they're not going to be willing to wait it out. So it may vary depending on who your tenants are. No one's suggesting anything. I guess I think this might be important to cover. Although the statute sets it up so that for a tenant to get out of it, if the landlord is not willing to terminate on their own, the tenant has to in effect demand that you cure it within 5 days. Well, that doesn't mean to suggest that the tenant has to believe that you're not trying. It's clear that landlords are trying and they're wanting their places back together in this circumstance. But sometimes the circumstances just have rendered it impossible. So the landlord can say, I'm trying every day, I'm trying as hard as I can. The tenant can believe that fully, but if it means the tenant's not going to have a place to live for the next month or 2, they ought to have some option to terminate the lease and just go try to do something better. I have one student who withdrew from school. He lost his laptop, he lost his books in the flood. He was so frustrated about the whole thing, he withdrew from school. He wants to go home to Georgia. He doesn't want to stay here and wait for a lease to be reconstituted for the rest of the semester, you know. He needs to terminate his lease. So I think that reasonableness is really maybe counterproductive to concentrate on too much when what you really have is different people's differing needs.
Yeah, I just follow up on that. Be realistic. Sometimes, you know, if it's going to be 2 months, you may have to terminate the lease. Just be realistic. Whether you're a tenant or a landlord, you may be facing that.
Well, and I will be a little bit of a devil's advocate. I think once you get to the point of the 5-day written notice, working days, the statute is clear and says the problem has to be fixed. The breach has to be remedied. So on the off chance that will be enforced by a court, I think people need to know that, because it doesn't mean you start repairs, it means it's done. And
It's habitable.
that it's an adequate remedy. It can't be, let's say, painting over mold. It has to be correcting the situation. So it's real important, because the 5 days does mean something in the statute.
Absolutely.
Right, and as long, we have like a, just so you guys know, we have stuff about 30 questions.
And we also have the, when submitted, we'll probably alternate between the written submissions and the people that are.
Thank you very much for your time tonight. I live in Boulder, and my husband and I own a home in Lyons. Luckily, the house is fine. It's amazing, it's fine. The tenants got out. It's a single-family home. They got out. We're in constant communication. They wrote us and indicated that they want to maintain their lease and move back in when the house is inhabitable, which is totally dependent on the town of Lyons and all the utility issues there. I talked to the town today. They said, yes, there are reports, it may be up to 6 months to get everything up and running, but they're going to try to get some temporary services in place. That's probably not going to be adequate for my tenants to move back in. The wife has a home office. We agreed that they would not have to pay rent in October, and I want to know how long, if they want to continue this lease, how long do they not get to pay rent? That's my first question. Second question is, the utilities are in their name, and the town is figuring out how they're even going to be billing people because they can't read meters. So they're thinking it'll just be a base rate. Do they continue to pay their utilities while they have this lease in effect, or does that resort to us?
Did you terminate the lease, or?
No, they want
They
to
wanna come
maintain
back.
their lease and move in when they can.
Okay. I don't think they're responsible for rent during that period.
For up
Or-
to 5-6 months.
Yes? Yes.
If you're willing to keep the lease open that long and not terminate it yourself,
Okay,
which is your option, then you're leaving the place there, they can't live in it, they don't have to pay rent while they can't live in it.
okay.
You do have the option of terminating the lease earlier and seeing if someone else can rent it. If it's livable to someone else. It was a little unclear to me whether it might be a problem for them, but other people might be able to
I
move
think it's
into
gonna
it.
be, for most people, not workable. There's no sewage, there's no gas, no electricity, no trash, nothing.
Yeah, you have a dwelling rental that you really can't rent because it's not livable at this
Exactly.
point. That's what it
Unless you
sounds
want
like.
to camp in indoor camping. That's what it is, it's indoor camping.
And you bring up a very good point, and sometimes when we focus on one statute, we forget sort of our general legal concepts, but there's a general legal concept called force majeure, which is basically when things outside of your control happen, you can pretty much throw, this is way oversimplified, but you can throw the contract out. So, you know, that's, when you access to the property, that's where that kind of stuff comes into play.
But I think actually I'm playing as a little bit of devil's advocate too, because there's some value to the tenant to pay rent. Because obviously they want to come back to that place. And if you're in a situation as a landlord where you say, it's going to be 6 months, but when it's done, I can, you know, it's going to be nicer than it was before. Well, that has some value to a tenant that is currently under a lease that's not at that higher rent level. And it may benefit them to say, you know, look, I'll pay you an extra month's rent, and basically what they're doing is reserving the right to move back in. That's the value to the tenant.
And storing their personal property.
Yeah, I was gonna say I had another
Storage
situation,
fees, right.
just like this, and I said, if all the furniture and all your clothes are there, it actually is impossible for you to rent it to someone else anyway, but maybe some agreement through a mediation or just through some negotiation with the two of you could say, well, it's worth this much as basically a storage unit for a certain time period, and they would pay some rent, but it's not going to be able to be used by any type of tenant for, you know, I mean, until utilities are reinstated. So it's just an idea.
And one last thing, just check your insurance too, depending on type of insurance, it might cover lost rents.
Can you address the utility issue quickly?
responsible.
Do you need the utilities to remain on, I guess?
They're not on, and we don't know when they will be on.
If they're not on, they shouldn't be paying anything.
The town is figuring this out.